Before we start the session, we would first like to congratulate Mr. BG Harindranath, who has been recently conferred the Senior Advocacy. Congratulations on behalf of Beyond Law CLC and those who watch this session. Right to privacy and freedom of information has been a facet which we all keep on discussing. But it carries its own trappings in the digital age. And what are the rights in this regard and freedom of information which we can understand? Being a Sunday, we all know that everybody is wanting that one should go about. But once you have resource persons like Mr. BG Harindranath, then one wants to decide whether one has to go for a session or for going around with the family. We are thankful to all those viewers who are watching us live on the YouTube and Facebook and on this Zoom meeting. And congratulations once again.
Thank you, Mr. Vikas, and thanks everyone, because on a Sunday you are spending your time with the. Am I audible? Clearly audible? So therefore, see, I'm very thankful to all of you. Very patiently you are waiting here and for the talk. Now, this is a very vexed subject, the right to privacy, right to be forgotten, and the freedom of information in the light of these rights which have newly come to the fore. Now, you find that this right to be forgotten, which is a new addition, came after the famous case, Google versus Spain, regarding Frank Costias, a lawyer in Spain. He had sued Google before the European Human Rights Court, and the judgment of the Human Rights Court actually brought forth this. Of course, there was his right was there, but then it really got expanded. Now, before I go into all these matters, I must say that we must first dwell on the right to privacy. What is meant by the right to privacy, and what actually we understand by this right to privacy. In fact, basically this right to privacy emanated in England in the 17th century. See, for execution of processes, the homeowner's right was recognized. First in Simian's case by Lord Coke. You would all remember Lord Coke was one of the great judges, Chief Justice of England, who first, prepared a digest of cases. Coke's institutes are well known, and that was the first time when, even before that, there were reports, but the reports in a chronological manner regarding common law was prepared by Coke, and Coke's institutes were followed by later common law judges. And you find the development of law relating to stare decisis or law relating to precedent in the common law jurisdiction. It got more entrenched after Coke's institutes. Now, in Simiani's case, the Chief Justice Coke's court recognized the right to the homeowner to defend his house against unlawful entry, even by the king's agent. But at that same time, it recognized the authority of the appropriate officers to break and enter upon notice in order to arrest or to execute king's processes for suppose it is connected with a crime or for investigation of such things. But unless otherwise, it was not possible under law to raid the homeowner, because he had every right to defend his house, even against entry, if it is an unlawful entry by the king's agents. Simiani's case is the origin of that phrase, which a man's house is his castle, and this is born out of Sir Edward Coke's commentary that the house of everyone is to him his castle and fortress, and it is a defense against injury and violence for his repose. And if thieves come to a man's house to rob or murder, and the owner or his servants kill any other thieves in defense of himself or his house, it is no felony and she loses nothing, according to Coke's judgment in Simeon's case. This sets that the common law rule of forced entry by bailiff, that is, king's officers, cannot be made into private homes except when there is a warrant issued by the court. Now, William Pitt, you would remember, William Pitt in Parliament, English Parliament in 1763, said that the poor man may in his cottage bid defiance to all the force of crown. It may be frail, his roof may shake, the wind may blow his house. Nonetheless, he is entitled to defend his house, which is founded on this right to privacy, enunciated in Simeoni's case. Now, after some time, you find in England, in Entick versus Carrington, a very famous decision which has been quoted by our courts as well. Like Hendrick House was forcibly breached by the agents of the king. That time, Lord Halifax was the Secretary of State. He issued a general warrant for search of Entick's house. In Carrington, an officer of the king's raided the house. It was held that no general warrant could be issued except for a specific purpose, and no man can set foot in the grounds of another without his license. And if he steps into that, he is liable for an action which was held in Entick versus Carrington. Entick versus Carrington is a famous decision which was pronounced in 1765. Now, after all this, you find the enlargement of this right to privacy. Right to privacy was initially recognized even in America and all the others countries, where there were independent judicial institutions, only against physical entrance. But the right was first against in the other domains, that is, domains of print, domains of photographs, and other matters. Limit of publicity was first recognized or put forth by Samuel Warren and Louis Brandeis in an article in 1890. Samuel Warren and Louis Brandeis articles are they published their article in 1890, and they recognize the right anchored in the Fourth Amendment to the U.S. Constitution. Now, United States Constitution, after the inception of the Constitution, there were amendments to the Constitution. Now you find First Amendment, which is called the Bill of Rights. There you find the right to freedom of speech, right to several rights, expanded in the First Amendment. The history of U.S. constitutional amendment is history of expanding freedoms, whereas our first amendment is curtailment of the right contained in Article 19(1)(a), freedom of speech, and several other amendments intended to advance curtail the right to property and intended to advance the agrarian reforms. Now, but U.S. Constitution, on the contrary, was the freedoms were enlarged by the amendments. That is the First Amendment. The Fourth Amendment recognized the right to privacy. That was introduced in the year 1789 by the fourth President of the United States, that is by James Madison. He introduced it in Congress. You remember the famous case Marbury versus Madison, pronounced by John Marshall, where it was held that the judicial institution, that is the Supreme Court of United States, is the ultimate arbiter of the Constitution and the laws. Now, that was the first time when a law was struck down by the Supreme Court, saying that it was violative of or ultra vires the Constitution, and that the legislative branch could not transgress the constitutional limits prescribed in the US Constitution. So this was followed by various constitutions, though there is no such right founded in England. But so far as our constitution is concerned, we have Article 13 and Article 226 and 32 provide, invest power in the court to set aside any law which is unconstitutional. Now you find this Fourth Amendment to the US Constitution introduced the right to privacy. It became part of the US Constitution in the year 1796. It read that the right of the people to be secure in their persons, houses, papers, and effects against unreasonable searches and seizures shall not be violated, and no warrant shall be issued but upon probable cause, supported by oath or affirmation. This is very important. You see, the warrant can be issued only upon probable cause. It should be supported by oath or affirmation, and particularly describing the place to be searched and persons or things to be searched. Now, this is unlike the warrant issued in Entic versus Carrington, which is a general warrant. The principle laid down in Entic versus Carrington, that is Lord Camden's principle, is actually verbatim extracted here. That warrant shall be issued only upon probable cause, supported by oath or affirmation, and describing the place to be searched. You cannot just run into any place. And then the persons or things to be searched. Otherwise, the people have a right to secure their persons, houses, papers, effects against searches which are not supported by the matters which I have just mentioned above. That is, unreasonable searches and seizures are barred under the Fourth Amendment to the US Constitution. Now, this Fourth Amendment to the US Constitution, initially it was understood as a right against physical searches, that is entry into homes and other places, private places. But then Samuel Warren and Louis Brandeis, who later became Supreme Court judge of the United States, he was one of the greatest judges of his time, along with Oliver Wendell Holmes. He is considered to be one of the jurisprudential giants in the US Constitutional Court, that is the US Supreme Court. See, they epitomize that the right of privacy is an already existing common law right, which protects even written or that is thoughts, sentiments, emotions which are communicated to others by letters or other means are also protected by this right to privacy. So everyone should have his private sphere. Not just if you write a diary in your house, no one can take this diary and read it. See, it only contains thoughts, sentiments, and emotions, and other writings, other personal matters in that. No one can read that. So likewise, your photographs, other new technologies which bring forth your personality in the open. So these are all part of within the ambit of the Fourth Amendment right to privacy. That was what the article actually meant. And that law, literary and artistic property, that was also protected. That was the gist of the article. So they said that they have when there is a violation of this right to privacy, the person can lay an action for tort for damages. Even in the absence of special damages, substantial compensation could be allowed for injury to feelings like libel, slander, all these things. And in certain cases, they also, when they said that an injunction in a limited classes of cases could be issued to prevent publication of personal matters. Now, Louis Brandeis' article was noticed in the US legal circles. And for the first time, this expanded right to privacy, which we understand now, was tested in Homestead versus United States. You will find that Louis Brandeis, that was reported in 277 US 438, that is 1928 decision. See, there, ironical to note that Louis Brandeis was a judge who was a party to the Homestead decision. Obviously, his view was an dissenting view. Chief Justice William Howard Taft, who delivered the majority opinion, said that the uh, right to privacy did not expand to the areas of intellectual rights or other property. Now, this was a case where there was a prohibition law in the United States those days. So bootlegging, it is this smuggling of liquor from Canada and other places. It was the offense was known as bootlegging, and they called it bootlegging because people used to hide the liquor bottles in the boots and bring it from Canada to United States. So this was also done through lorries and other things. I don't know how many of you have seen the Kevin Costner movie Untouchables, where they brought down Chicago's famous Don mafiosi Al Capone. That movie is known as Untouchables. Marvelous performance by Kevin Costner. And now this bootleg, there was wiretapping. You see, those days wiretapping was till then not known. Wiretapping is telephone calls were tapped by the police, and evidence was obtained from this illegal wiretapping. They did not obtain permission from the court. The question was whether use of evidence disclosed in wiretapped private telephone conversations violated the parties' Fourth and Fifth Amendment rights, right to privacy, in other words. Now, obviously, there was no compulsion to induce the defendants to talk, and it was just eavesdropping. People were just listening to what. So the majority held that it did not violate Fourth Amendment. Fourth Amendment, they said, it only uh, interdicted physical entry, and it did not contemplate the telephone eavesdropping of telephonic conversations, because when the Fourth Amendment was enacted, there was no telephone. The founding fathers only intended that the violation should not be into the physical sphere and not to the other spheres. But then, in a dissenting opinion, two of the great judges, that is Louis Brandeis, the author of the article, and Oliver Wendell Holmes, held that such right did inhere in the citizen under the Fourth Amendment. Now, uh, this view was later, the dissenting judgments later became the law of the land, and the views of Brandeis and Oliver Wendell Holmes was later, dissenting judgments were accepted by the majority, and the old decision, that is the decision in Homestead's case, was overruled by the US Supreme Court. Now you find there are other decisions. I don't want to go into these decisions because these are because of the time constraints. If I go on speaking about this, it will go on for eons together. So one decision is Griswold versus Connecticut. That was in 1965. I just wanted to say this because, see, there is now in the United States, after the Reagan's period in 1980s, the Supreme Court of the United States increasingly is veering towards the right. More conservative views are coming, because after the now the United States Supreme Court, 9 judges, 6 of them are Republicans, and they are very their views are highly conservative. We had the Roe versus Wade, a decision which uh, you know that, the right to abortion was upheld in Roe versus Wade. But recently, the US Supreme Court has overruled Roe versus Wade in a Texas case. Now, I don't want to go into that, but I will just, I'll come back to Griswold's case in 1965. That is Justice Douglas. That was a case where married persons, they had the right to use birth control devices. So the Connecticut statute, Connecticut state of Connecticut, anti-contraceptive statute was enacted, which forbade all married persons the right to use birth control devices. Justice Douglas found this very obnoxious, this statute, and he, delivering the majority opinion, upholding the uh, dissenting views of Oliver Wendell Holmes and Justice Brandeis, observed that in the private realm of family life, it is difficult to imagine what is more private or more intimate than a husband and wife's marital relations. This is an area where the courts or the state cannot enter. This is an area where a person's privacy has to be protected. And Griswold dealt with this governmental intrusion into private zone of one's home, and it has been held to be forbidden by the Fourth Amendment. Now, uh, now this another decision is Kylo versus United States. You know, that is a U.S. Supreme Court decision. We have now thermal imaging devices. Now, from a public street, you can detect heat levels in a private home, and you can, I mean, watch what is happening in the private home by the detecting heat levels. The Fourth Amendment to the US Constitution, the Supreme Court held that it draws a firm line uh, at entrance of the house. And in Kylo versus United States, which is a decision of 2001, they said that this is a forbidden area. Forbidden area. Now, I'll come to the Google Spain case later. Now we will go to the from the US right to privacy and press freedom in Time Incorporated versus Hill. That was a 1952 case. Now I have spoken about right to privacy. Now we come to the realm of press freedom in the United States. Quite often, these private matters, obviously, the press report many matters in the media, and sometimes this right to privacy comes into direct conflict with the right to the press or press freedom or right of the people to know what is happening in the locality. Now, one decision is Time Incorporated versus Hill. That is a 1952 case. That is a case where escaped convicts, intruded into house of James Hill, and the family was held hostage. And after some time, they were released unharmed. The police went after the culprits. Two of them were shot dead. Then the family insisted that the intruders did not ill treat them. And because of the prying eyes of the press, they shifted to faraway place. But you see, Life magazine sent its men to the former Hill family house, the place where they had shifted, and published a news item that the family were ill treated by the intruders. I mean, the people who, the culprits. Now, New York Supreme Court, they went to the US Supreme Court after the decision, and they said constitutional protection for free speech, and US Supreme Court held that, that in the absence, now the press has a right to publish what is true and correct matters, and that there cannot be an injunction against a publication in the absence of proof that the matter which is published was published with the knowledge of its falsity or reckless disregard for truth. So, US Supreme Court, when this right to privacy conflicted with the right to the press or the freedom of expression, they upheld the right or the freedom of the press in contradistinction to the right to privacy. Now, another decision is Cox Broadcasting Corporation, where rape victim's name was published. That was from public records. And then the US Supreme Court said that press cannot be said to have violated any law to right to privacy if it publishes the name of the right of rape victim, because it is there in the public record. Now, but now, so far as India is concerned, you all would know that under 228A of the IPC, the rape victim's name cannot be published. And now, what is important is balancing of the competing rights. Now, we have a right of erasure, what is called right to be forgotten, or right to privacy. Right to be forgotten is a part of this right, right to privacy. Now, many a times you will find that the right of erasure conflicts with the right of the people to know many things. Now I will come back to the Google versus Spain case. Costia, Franco, that Mario Costia Gonzalez, he was a Spanish citizen in 2010. See, some 1998, there was a Spanish newspaper had published some reports of financial dealings of this Mario Costia, and now suppose you search the Google search engine, you get the and you type the name of Maria Costia Gonzalez. They will take you to the this link will take you to the Spanish newspapers website, and you will find there the news about Costia Gonzalez financial dealings, which obviously Mario Costia did not want the people to know. He wanted this this link to be deleted from Google's search engine. Now, this is the subject matter of the case. Now, he said that he has a right to be forgotten. He does not want people to intrude or people to know about his former financial activities. Now, because it is part of his right to privacy. Now, the other day, before going into the merits or demerits of this Google versus Spain decision of the European Union, let us look at what is happening in the internet. Now, I feel that the internet is ubiquitous; it is everywhere, and your data every day it is changing hands. Why I say this is because if you book a flight ticket, or if you search for a flight ticket in a website, I mean, for instance, any of these websites where you can now book ticket online, then right into your mail's advertisement column, many of these sites send Google, Facebook, everyone sends the prices of various these flight booking companies. They say their advertisements come into your page. So, by use of AI, artificial intelligence, algorithms, and this, because we live in what Cass Sunstein says, #Republic, everything comes into your mail, everything comes into your Facebook page, or whatever pages you use for this. I mean, social media pages you use or you frequent, it comes. So what I'm saying is that they immediately know where you're going, what you're doing. Now you go to a shopping, go do a shopping, you swipe your credit card, and then the credit card sends the details of what you have purchased to the card company. The card company gets the data. This data is processed by some artificial intelligence company. They know you have purchased a white trousers and a white shirt, so they understand that this person has got a liking for a white shirt and a white trouser. Now, over and above this, you have purchased a advocate's band. All right. So people know your they know your profession also. Now you search in the Amazon for some books, some law book, several law books. I mean, the page shows you these are all connected with this. These are all purchased by people who have purchased these books, and you see, you have there is little uh, right to privacy if you look at it that way, because your data is data mining companies. These are all in the sphere, and how far this personal data protection would help you is again a chimera. I mean, I say this right to be forgotten is a chimera in this internet world, because internet knows everything. See, there is nothing. Internet also never forgets. If you ask me, I was watching the other day the John Oliver's uh, talk show. I mean, stand-up comedy. Last week tonight, I don't know how many of you have watched this. He was speaking about Maria Costello, whom I've just spoken to, who had filed a case against the Google Spain in the European court. Now, he says all that he remembers about Maria Costia Gonzalez is now his 1998 financial dealings. Because now he has become world famous because of this decision, and everybody knows. Because till then nobody knew. Now the entire world, I mean, legal world knows that Maria Costia Gonzalez has some financial problem in 1998, and he wanted this to be taken out of the website. Look at, and what is the net result of the application filed before the European Human Rights Commission, I mean, European Human Rights Court, and is right to be forgotten. Or no, on the contrary, nobody is forgetting that. On the contrary, people remember more and more because of this case. Like it is like this: you go to the court, you fight a case, then some other way, why you have fought the case, and everything comes out, and people get because this is all ubiquitous everywhere. Internet is everywhere, and as I told you, this right to privacy in this digital age is some kind of a chimera, and it is absolutely impossible, because if you pass a law here, we have a data protection law in India, but beyond the Indian shores, beyond our boundaries, this law has no application. You cannot ask Google Incorporated to take down my matters about me, which is being shown in Sri Lanka or other neighboring countries. But in India, of course, they can ban because of the Data Protection Act. They can issue orders, but not other places. Now, let us come back to Maria Costia Gonzalez case. Maria Costia Gonzalez case, the if you type his name in the Google search engine, you would receive publications regarding the confiscation order of his house. See, because of the financial dealings, his house was confiscated. The Maria Costia Gonzalez demanded that the newspaper erase his name and publication, that Google engine remove his personal data in issue from the results it provides to its users. The Spanish Data Protection Agency dismissed the claim. Then, then later on, the Google Spain's case, it went to the European Union, Court of Justice of the European Union, CJUA, regarding the correct implementation of the. Then they held that this has to be removed, and they also held that a legitimate interest to deny, that is the subject, that is Maria Costia Gonzalez had a legitimate interest to deny the disclosure of his personal data, even if such disclosure is not harmful. Nonetheless, and they founded this right on right to privacy. Now, this is what is known as right to privacy. Now, if you look at this in another discussion, which is a Western discussion before, which I watched online some 2 3 years back. I found that see the in European Union and other places, most of these requests, come from people who have been convicted offenders. Some of them for my minor sexual offenses against minors who have been convicted. They want their data to be erased. Now, now this is a peculiar situation. Now, in our country also, because now I am practicing in the High Court, and before I used to appear for the High Court, and we have every day we receive one or two cases where the subject, wants his name to be erased from the court records, and so that it does not appear if Google search engine. If you search the name, you will find that he had applied for a bail in a murder case, or that he has been convicted in a murder case. All these people come before the court and say that they have got a right to be forgotten because it should not be published. Now, these and other minor offenses, most of these things, which there is you cannot, this right is in conflict with the right of the people to know what is happening in our country. See, people have a right to know what is happening in our court, what is the net result of a case, because it's an open court system. In an open court system, there cannot be a right to of erasure, except in those matters which have been are enumerated by various statutes and judicial decisions. I shall come to that at a later stage in our talk. Now, the European Union data protection is generally not accepted in toto in America. Now, there is a learned author, Michael Douglas. He has written an article questioning the right to be forgotten. You will find that in the 40 alternate LJ 109 2015. That is the citation which you will find in, if you subscribe to the Fine Online, it is available. Now, Michael Douglas says in his scholarly article, he said that although Americans are increasingly wary of intrusions into their privacy, we need to remember that they live in the land of the First Amendment. First Amendment is the same thing as our Article 19(1)(a). In the wake of this Google Spain case, Harvard Law School's one academician, Jonathan Citrain, said, it is a form of censorship that one is most likely to be unconstitutional if attempted in the United States. Now, I'm asking myself this question. This scenario of right to be forgotten, can we ask the courts to, can the convict ask the courts to remove his name or get his name erased from the judgment if he is convicted for any offense? Any offense. Because this again is a land of Article 19(1)(a), where we have the right to freedom of expression, which includes the right to the free press to report matters. See, this right to privacy in our country has to be, be a resistance on two values in particular. One is the value of the free press, and secondly is the value of the free market. Because media in our country is expected to uncover the truth and report it. Not merely the truth about government and public affairs, but the truth about people who live in this country. See, when they collide with expectations of privacy, well, I tell to myself that privacy must always lose. Because the right of the public to know stands on a higher pedestal. It is directly founded in Article 19(1)(a). See, right to be forgotten when it is adopted in our country has to be subservient to Article 19(1)(a), the right of the people to know that. Now, obviously, There are exceptions to this. Every right is not absolute. Right to the press has inbuilt checks in 19 Article 19(2), which is brought about by the First Amendment to our Constitution, and also other laws pertaining to defamation, obscenity, and public order, and these things are there, and therefore that right to be forgotten and the right to privacy, when in juxtaposition to each other, has to have a ground where the data privacy does not override our right to know things. Now, if suppose you are an investor, you are trying to invest in a company, and then the company has got its promoters uh, on whom you are relying, and you are going to place your wealth in that company. So these companies directors may have been involved in some other business, and that must have collapsed. It must have gone to smithereens, and there must be a case pending in the NCLT regarding the proceeds of that company, where it has gone. It is a tottering company. So you want to know about that, and then if suppose they use their right to privacy and want this information deleted from the uh, website, Google website, or wherever it is, it affects your right to know. It affects your right to, and freedom of expression, freedom of the press, and search engine link obviously would directly take you to their antecedent activities, and necessarily you would not, obviously you would not invest in that company. Now you will know the antecedents of the person's promoters, and if they are successful and if they are known for their honesty, you may do that. Or if you are dealing with a dealer, you find that there is a case, several cases under Section 138 of the NI Act, which are pending in various courts. And he says that, look here, this is my private matter. Somebody has filed a case against me. Therefore, my name may be erased from this. And nonetheless, let the case go on. But again, I must say that people have a right to know. And when a matter is in the public record, nobody has an unfettered right to get it erased. And you cannot bank on right to privacy to get it erased, because or the right to be forgotten now newly being discovered by courts. No. So this is what uh, my personal view on this right to privacy or right to erasure, the new right to erasure is concerned. Now, now recently uh, now I just want to come back to our right to privacy in the context of the Constitution of India. Now, you find that during the Constituent Assembly debates, Somnath Lahiri, in fact, proposed a provision akin to safeguarding privacy correspondence. You will find it in Constituent Assembly debates, that is Volume 3, 30th April 1947. 30th April 1947. You see, this plea was rejected. This plea was actually rejected. And then you find that then we have the 8-judge bench of the Supreme Court, and MP Sharma was Satish Chandra. One of the largest benches. It was not a 9-judge bench, but an 8-judge bench where one judge, those days, you find the Supreme Court sitting in 6-4 because one judge was ill. So we had an 8-judge bench. They used this piece of constitutional history and refused to read in the right to privacy under our constitution, under our provisions of the constitution. They said in MP Sharma Satish Chandra, they said that there is no right to privacy akin to Article 4th Amendment of the US Constitution, which was expressly rejected by the founding fathers, and referring to the Somnath Lahiri's proposed amendment, which was not accepted by the Constituent Assembly. Now, later in Karak Singh's case, sixth judge bench again, where Justice Subbarao, one of our great chief justices, he issued a strong dissent. He said that though the Constitution does not declare the right to privacy as a fundamental right, but the right is as an essential ingredient of personal liberty. The majority held that the nocturnal domiciliary visits by the police were unlawful on the basis of expression personal liberty under Article 21. Then we find the Gobind Singh's case was the state of MP, 75 Supreme Court, 75. If you want to note the decision, 75 2 SCC 148. Then majority, they drew on Karak Singh's case. They looked into. I'm not going to all these details of the cases. Then we come to Rajagopal's case, that is the state of Tamil Nadu. Now that is the famous Otto Shankar's case. He wanted to publish his life story. His Otto Shankar is a known criminal in Tamil Nadu, and he had connections with the very highly placed police officers. And police officers were fearful that disclosure would, the publication which he was writing from his jail, would create problems for them. So they said they had a right to privacy, and this publication should be prevented. But then the court obviously did not agree with it, and they said that there cannot be. They also held that when it becomes a matter of public record, no right to privacy survives. Now I come back to the case of MP Sharma's case. Then though it does not specifically adjudicate right to privacy, but they held that the unlawful searches, the Fourth Amendment is not there. But now, after K.S. Puttaswamy's case, MP Sharma, that is 9 judges. K.S. Puttaswamy's case, they have specifically overruled MP Sharma's cases. And now they have founded this Fourth Amendment right, a right to of the US Constitution in Article 21. The Puttaswamy's case, they specifically held that privacy is a constitutionally protected right, which emerges primarily from the guarantee of life and personal liberty in Article 21 of the Constitution. Now, elements of these rights, it's an elaborate judgment running into about 900 pages. I don't want to go into each and every facet of that judgment. But they categorically held that elements of privacy arise in varying contexts from other facets of freedom and dignity, recognized and guaranteed by the fundamental rights contained in Part 3 of the Constitution. Now, this is reported in 2017-10 SEC, page number 1. Now, on the touchstone of this Article 21, right to privacy is now part of our constitutional law, part of our law. And however, the same judgment, their lordships had held that right to privacy is not an absolute right. Right to privacy, depending on its variable facts, one part or the other, could be subject to restrictions of exercise in that particular fundamental right. So this is so far as right to privacy and other matters are concerned in our country. Now I have almost spoken for an hour, and I don't want to go into each and every aspect of this. I just want to say that this right to privacy, which is now recognized in Puttaswamy's case, of course, and this right to be forgotten, which is part of that, cannot, however, override the right of the people to know. It is not an absolute right, and it is subject to Article 19A of the Constitution of India. So this is now open to debate, and this evolving constitution, we will find more scrutiny of the subtle nuances of these rights by our Supreme Court. Thank you for spending your time for about an hour. I hope I have been able to make, because recently I had also argued one case before the High Court, that is a division bench decision where this right to privacy was involved, and the division bench of the High Court, in fact, held that right to privacy is part of, like it is followed the Puttaswamy decision, but nonetheless, so far as the right to be forgotten is concerned, their lordships held that these matters have to be examined case to case basis. Depending, now there are statutorily protected rights of anonymity. For instance, 228A of the IPC, which says that rape victims' names shall not be published. That is statutorily recognized, and also the Supreme Court has held, though it is not applicable to High Courts and the Supreme Court, but Supreme Court has held that it should not, in judgment, so far as the name of the rape victim should not be published. Secondly, in matrimonial matters, there is the Family Courts Act, and there are other enactments which interdict the publishing of the names of the parties. And if parties exercise their right, the division bench in Vaishak's case, that is a reported decision, Vaishak's case is held that they have an absolute right to get it erased. Thirdly, in matrimonial matters, then thirdly, it is in matters of juvenile justice, where after the conclusion of the proceedings, statute itself says that it should not be published. And in a case-to-case basis, where there are rights akin to this, where the individual would be put to great harm. For instance, if someone makes a complaint to the police anonymously, or a whistleblower or somebody, if he is, even the police want to keep his name anonymous, then obviously he has got a right to see that his person is protected. Likewise, case-to-case basis, Kerala High Court held that it has to be examined, and the right to be forgotten is not absolute. And that the article, this is in, it has to be balanced with the right contained in Article 19(1)(a), that is the right of the press to, and right for people to know, that is right to information. Thank you, Anand. Thank you very much.
Thank you. The session took us to the various spectrums of law, coupled with the judgments. I'm quite sure that after hearing your session, they can look deeper into all these judgments of Khadak Singh and all. And the interplay between the acts which provide protection ipso facto, and we have all seen that after the judgments of the Honorable Supreme Court, how we write in case of victim, etc., X rather than prescribing the name. That's a marvelous journey, and that protects everyone. And we are always indebted.
I just wanted to add one more thing. Now we have a data protection law, which has been enacted by because I did not want to go into those matters because it would consume a lot of time. 2019 enactment.
You can, the law is such that you can deep dive as much as you want, and you will keep on enjoying the journey in that process. So thank you, Mr. Harindranath, for sharing your knowledge.
Thank you.
Thank you to the participants, and those who have missed previous webinars of Mr. Harindranath, or for anyone, you can watch the YouTube sessions on the Beyond Law CLC series, and if not subscribed, you can subscribe to that. Thank you. Namaskar.